Hey y'all, what's up? Welcome back to my channel, y'all. So in this video, I want to talk about my case with Resurgent, okay? So, y'all, I lost that case. But what I have learned is that even though you think a case might be over, you got to realize when you're pro se, even though you think a case might be over, it's all in, there's always a strategy behind it. Let me put it like that. The reason why I say this is because not only was this my first case that I went into actual court with, because I've been in arbitration, but I've never been in at this point, I wasn't in the actual court yet, right? So I haven't been able to get in front of a judge or get in front of a lawyer, and they can be very intimidating. While I wasn't intimidated, because I don't get intimidated easily, it was more of just the whole scene. Like, y'all, I was literally the only person who was trying to defend my case. Most people was trying to settle out. Mostly because, you know, out of fear or out of intimidation, but I don't operate like that, y'all. I can't. It's like, if I know somebody is doing something wrong, I cannot let it go. Especially if you're doing it wrong to me. It's different. I don't jump in people's business, but if you're doing something wrong to me, I feel like I have to be the one to rectify that, because at the end of the day is my life. Like, you can't just do something to me and think I'm gonna lay down and take it because you're a company. Like, that just doesn't work for me. So yeah, so when it comes to this debt collection, honestly, I think this is the whole point of me even doing, I don't like bullies. Like, that's the whole point of me even going this route, because I just feel like the more I research, the more I'm finding out. I'm like, y'all not even true owners. Why would I pay somebody that's not even a real owner? And then to have little to none or little to no information to really try to prove it. Like, the state courts are accepting like anything to prove ownership. That just doesn't make sense to me. So I'm the one that will defend myself, because I have every right to. We have consumer laws, and we can, you know, it just depends on how far you want to push yourself. And I'm willing to push myself all the way, because I just don't like bullies. And I feel like debt collectors are bullies because you're inserting yourself into a debt that you were never a part of that you were never a part of at the origination, or when the line of credit was originated, right? So cool. So that's like part of my motto. So with that being said, Resurgent. So LVMV and Resurgent are sister companies. LVMV sued me first in July of last year. Resurgent sued me in September of last year, right? So with that being said, I was like, okay, you know, I felt like that was the enemy trying to overwhelm me, but your girl I don't scare away like that, like not that easy. They sued me in September. We were having issues with the actual courthouse. Like, they took forever to because I had inserted counterclaims, so they took forever to review my fee waiver, because if you're going to insert counterclaims when you haven't answered, then you have to pay the amount of the motion, and the motion was $25, right? So okay, cool. So I go ahead and I filed my fee waiver. It take almost a month, and then I had called them. So I'm like, you know, what's going on? They gave me the runaround. She wound up saying, oh, it hasn't been reviewed yet. 2 days later, it gets reviewed, it gets denied. I'm like, how I get denied when it got approved in another court? So then I take a look at it. It was my fault because I did not attach a document. So I do it, and then that made it take a little longer anyway. And then the holidays, y'all already know how the courts go with the holidays. It takes even longer. So we finally get in court in 2026, and I already knew. Let me put it like this. I filed a motion, right? Like, I asked them for discovery. I filed a motion for to compel discovery. He granted it, y'all, on a Friday. Why that Monday he retracted the whole order and basically said it had already been fulfilled, because when Resurgent sent their answer in, they was like, oh, we already answered the interrogatories. Mind you, they were already out of compliance because they never answered the interrogatories within the 30 days, which is law. But they blamed it on the whole court situation. So okay, cool, but then tried to blame me and say I didn't answer them when I had proof that I answered them. So like, let's be real. So I already knew that Resurgent was being shady anyway, right? So, and then these are lawyers that like have a bad rep because they have already been sued anyway by I don't know if it's by the CFPB or by somebody else for deceptive practices. So I'm really not about to let up on y'all. Y'all done, like, when I tell y'all they didn't mess with the wrong one, oh, y'all finna know my name by first and last name. Like, I'm not giving up. I'm not giving up until I exhaust every single avenue, okay? So yeah, so they had wind up, okay, so I already knew they was being shady anyway. Cool. So then they finally sent me the discovery. The only thing they did not send is the fact that they have a surety bond. They're like, oh, this is like basically saying they don't need to. So that's when I filed my motion to compel arbitration. He retracted it and was like, I don't want to see another motion in my court. Y'all come duke it out, basically. So I'm like, okay, cool. Y'all, when I got in that court, I had felt the way, but then I went into the bathroom, gathered myself together, and then came back. Mind you, I was there from 7:45 to 3 p.m. This is how you know they treat these cases just like a case number, and not really even wanting to hear people out. They just, like, the way he did it was, the way the judge did it was, he was like, yo, everybody has to go through mediation. Y'all go in there, boom, and then you can come back. So we're going to mediation. I'm telling them, like, oh, you know, this, that, and the third. They're like, I'm telling them my position. They're like, oh, you don't have no real damages. Yes, I do. If you are reporting incorrectly, then there's a whole federal law, 15 U.S.C. 1681S-2B. Like, what are you talking about? That says, that is the consumer law that says you have to make sure that you are reporting the maximum accuracy on my credit report. How you want to tell me that's not a damage? Obviously, what are credit reports used for? They're used for to prove credit worthiness. So if you're reporting something that you're not legally able to report, then that time frame that you're reporting it and it's hurting me because you're reporting it as a collection and as a derogatory account, how is that not damages right there? And then if I happen to apply for something in between that time, then that's another assertable damage. Like, he made me seem like I didn't know what I was talking about. He made it seem like I had no case. I'm looking like, okay. So now what I should have did was compel arbitration, but I did not do that. So it is what it is. I wanted to try to see how it was in that court, y'all, but court is something, because them just like you gotta be on your P's and Q's for them. So cool. I already knew once I got in there, and he was like, if you have any third party documentation and you don't have a witness for it, we're not accepting it. I was like, oh, well, my case is over, because I had credit reports and I didn't have nobody to witness them, but everything, I had credit reports that was my proof. And then I had proof that I had filed for something and I got denied during the time frame. He did not accept that. And then that was it. So he didn't accept none of my stuff as evidence, none of my exhibits as evidence. I'm looking like, when we first went in there, the lawyer ran it down. He called his first witness. She worked for Resurgent. She basically just said, like, what's the day-to-day operation? She's involved in this and the third. Now, mind you, y'all, the person who signed the affidavit that they sent me is not even the same person who was the witness. That threw me off. But I still sat there. I might have sat there a little crazy, but I still sat there. Now, mind you, when it's time for me to cross witness, they looking at me like, yo, you really doing this? Yeah, I'm doing it. Because I have the right to. Like, why y'all, they just tried to make me feel so uncomfortable, but I still kept going. So I asked her, I was like, you know, where is the purchase agreement? Because the purchase agreement is supposed to be with the, this bill of sale. And because y'all have not attached it, then I can't fully see what the terms and agreements was of this so-called sale. So the judge was like, I'm just going to let you know this is regular, like basically saying it's regular for a purchase agreement not to be with it. But then how can you say this is complete if the purchase agreement is not accompanied by, or if the purchase agreement is listed but it's not accompanied? That's like saying we don't have to have the schedules with it, but the schedules have to go with it to see who was listed in the actual sale, the transfer. So I'm looking like, okay. So I had that, mind you, because I don't really know what to say, like what to kind of come back, right? Because I'm saying, so I'm like, so he was like, well, what does that have to do with anything? It's a purchase agreement. If it's referenced, then it has to be included. What are we talking about? But he was like, I'm going to accept it as it is. Okay. Boom. That's one thing. My credit reports, he basically said everything. This judge basically said everything that I said was a legal argument. He was not accepting none of my documentation because he don't have nobody from the credit bureaus to attest to how these were pulled or whatever. I'm looking like I pulled them. These are compiled by the, like he don't understand. Basically what he was trying to say was he can't attest to how these reports are compiled because Experian or TransUnion or Equifax is not here. So I already knew I lost from them, right? But at least I thought I had them on this, right? Now, mind you, there's a statute in my state that says anybody who practice any debt collection practices have to have a surety bond of $5,000 and it has to be registered with the Treasury Department, right? Now, they do have you can write into them and to see, like to check to see if a company has a surety bond. I did that. I did not have no, like, they never responded back to me. So I'm like, okay, that's why I asked them for it, because why can't y'all provide that? That tells me something, very much something. It's giving something sneaky. Cool. He was like, so I at least thought I was going to have him on that. I'm like, okay, well, they never gave me that, so maybe it's something there that I could use. Y'all, he was like, well, you know, I didn't know what the statute was. I mentioned it, but I didn't, y'all, it was a lot. Because when I first did that, that answer, I was still kind of new to it and trying to figure out how to craft certain things or whatever. So it just was all over the place. Anyway, I wind up saying, okay, he was like, I'm gonna let you, basically he tried to give me another chance to go do mediation. I'm like, no, I'm not doing mediation because I already know that they don't want, I already know what I want and they know what they want. They're trying to put me on a payment plan. I'm not being put on a payment plan. You're telling me I owe this, I'm telling you I don't owe you. So therefore, we need to figure it out. So I said, I don't want mediation. So he was like, well, I'm going to take a break. I'm like, okay. So he goes and takes a break, or he put us on a break. So then he's like, basically trying to give me one more chance before, because he, in my opinion, he already knew he was going to give it to him, but he's trying to give me one more chance to get out of it. No, I'm not getting out of it because I don't stop. I don't care how many people, because everybody else settled out, y'all. I was the only one. I don't care. This is your job. You're a judge. You're supposed to be fair. You're a lawyer. You're supposed to do your job. I don't care if you deal with these cases 1,000 times. That's what you try to say in mediation. Oh, I deal with all these. I get all these cases all the time. I don't care. Like, you telling me that don't mean nothing to me. I don't care if you had 1,000 cases the same. I'm that one that's different. Okay? Because I actually did some research and I actually looked up some stuff. So let's be, you know what I'm saying? Let's be for real. Because the thing is, most people don't never challenge these people. And just because they're lawyers and stuff, I don't care what your title is. I have rights and I'm going to assert them. Now, I might not know how to do it or how to, wiggle my way out of certain things that y'all do or say. But at the end of the day, it's worth trying. Like, what is it going to hurt for me to try? Nothing. So I'm going to try. So we went on break and then he came back and he was like, I'm just going to let you know from everything that they presented. He said this before. He was like, everything that they presented, I'm already inclined to like give it to him basically. And I'm just like yeah, I just had to face like, okay, I'm still moving forward. You know what I'm saying? Because at the end of the day, I can appeal. If I already got approved for a fee waiver here, I'm going to get approved for, or the approval follows with the appeal process. And I knew I was going to get, it's no way that my appeal can be, even because with appeals, they're looking for legal errors. And he applied that law wrong. And I'm going to tell you why. So when he came back, he was like, he made his decision or whatever, right? Boom. I had got on the stage and everything, y'all. I testified. It was the whole thing. It was a lie, whatever. When we got to that statute, he just was like, excuse me. He was like, there's a lot of laws that govern, debt collectors. We don't know them all, da, 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 da. I said it's a New Jersey statute. I can't remember it off the top of my head, but I know it applies to them. So we took a break. He went to go figure out what the statute was. He was like, and then he came back with his answer. Now, or this wasn't a break, but this was right before he came back with his ruling. So he's like, yeah, Miss Colvin had came up with, or he's like, plaintiff or defendant comes up with her, that she mentioned the statute is this, but there's an exemption. The exemption is for attorneys at law. Mm-hmm. I'm looking like, yeah. Now, mind y'all, I'm thorough, so I don't just read just the first thing and not try to see if anybody can get a way out of this, right? So I'm saying that to say, I knew what the exemption was, but it doesn't apply to the debt collector. So he misapplied that to say as if because it applies to the lawyers that it extends to the debt collection agency, and it don't. Y'all are an agency. Y'all are operating in the business of collecting debt. So you have to have the surety bond. This has nothing to do with the lawyers that you have represent you, but because it said attorneys at law are exempt, he used that as an exemption. What? How can you use that as an exemption when it don't apply? I never said them. I am in court with Resurgent, the company. I'm not in court. I am in court with Resurgent, the company. It's Resurgent against me. But PFW, which is the attorney's office, is acting on the behalf of the of Resurgent, just so that Resurgent is not here. They're not pro se. They have representation. That's it. So how do you apply a law directly to the attorneys, but not to the company I'm in the lawsuit with? Like that's what I'm saying. He tried to misapply that law because he did not want me to win, y'all. He did not want me to win. That man did not want me to win. So I'm sitting here like, yo. he didn't want me to win because, again, I'm the only one who is challenging them. I'm the only one that's continuing. Everybody else settled down. They was ready to get in and get out like it was, they, again, treating it just like a number. No, baby, I'm not a number. Y'all finna know me. And the thing is, I don't care about losing because, again, this is all just a lesson for me. But at the same time, I'm learning to obviously win at some point. But the thing is, a lot of people don't keep pushing because when you lose, you like, you feel defeated. I get it. I felt defeated too because I lost with them in that case. But the slow and steady wins the race. It's not over. But see, this is the thing. They try to put the pressure on you. But this is why God is so good. And this is why God has to refine you when you surrender to him, right? Because we're not supposed to be acting off of emotion. You're supposed to act with clarity, okay? And when you lose a case, obviously any type of losing makes you feel frustrated, right? So it is what it is. But the problem is they just don't expect people to keep going, right? So then, and I'm gonna tell y'all when I get to the end how they even kept trying to push, like they're trying to put the pressure on me, but your girl don't fold. So boom, he goes in, he says that they are exempt, so he awarded them the amount of money. Now it was $2,500. I'm like, okay, cool, right? So I let it be that. We left. We got our order. I walked out. I'm frustrated. I mean, I had a headache. I didn't eat nothing all day. It was a lot. But I went home, took me a nap. Next day, I said, I'm not giving up. I have the right to appeal. Why do y'all think we have an appeal? Because we have an appeal process because judges have a lot of discretion and they are people. You can make a mistake. You can make a mistake. Now, whether they doing it on purpose or not, that would be the matter of opinion. I believe that he did it on purpose, in my opinion, because I was there. I'm the only one, and this black girl is not about to is not about to show out like this. She ain't even got her stuff together. We not about to give it to her. Cool. I don't need you to give it to me, but I need the appeal process to see that there was a statute that was misapplied. Okay. Therefore, because they did not have that information at that moment. So we already at trial. What, you gonna stop the trial to say, oh, we'll come with it tomorrow? Like, I mean, they didn't have it. And on top of that, it has to be validated because LV Envy already didn't have it. I mean, they had theirs, and with my other case, LV Envy had theirs, but theirs wasn't even approved until 7 days after they sued me. So they shouldn't even have been practicing no type of debt collection practices. I'm already going their behinds. Like I said, they finna know me by first and last name because y'all done messed with the wrong one, right? Boom. If y'all think y'all gonna put the pressure on me, pressure is finna be put on you too. Because again, y'all are a company. Y'all are an entity. I am a person. Y'all are people. Like, it's no different. You just might have more experience than what I have, but what y'all think I'm doing it for? What you think I'm doing it for? Like, that's the whole point. You know what I'm saying? So then y'all can't be putting people in a bind. Like, that's the thing about it, right? So cool. So he rules, I feel away, whatever. The next day I'm like, okay, we gonna figure this. We finna figure this out. So procedurally, after the order is put in, they can file a writ of execution. They can, levy your bank. If your state has wage garnishments, they can do all of that, right? I don't operate under my own social security number. So y'all not finna get no money out of me. I already knew it, right? Now, they put a writ of execution in. Now, here's another thing. They put a writ of execution in for a bank levy of a bank that I don't have. So I'm like, I don't think y'all gonna get nothing. But the bank that they're trying, that they put it in for, I used to work there. Now, keep up with me, y'all. I used to work there. I had issues with this company, with this bank. Now, if you're able to retrieve anything, mind you, y'all already know when y'all have to open up a bank, right? Or when you have to open up a bank account, you know you have to give your social. So if my social is connected to a bank account that I know I don't have, we have a whole nother issue. We have a whole nother issue. And that's a whole nother lawsuit. And trust me when I tell you, I'm coming after everything. I'm coming after everything. So they did a bank levy on something. I don't know if it has come back yet or not because it hasn't been uploaded on whether or not anything has been given. But I just say, let me just say this. I don't operate under my own social. You're not going to get nothing from me. But in the meantime, in between time, guess what? I put this case in appeal. I already put it in appeal process because I know that that law was misapplied. When you read the law, y'all, and I'm going to put it on the screen right here, the statute. It literally says in the first part that anybody who is in the business of soliciting advertising debt, collecting debt on the behalf of somebody else, or just collecting debt in general, you have to have this bond. If you don't, there's a $500 penalty and something else, whatever. But also, if you don't, you cannot practice debt collection practices. You cannot act like You cannot collect debt. That's what it's saying in the show. You cannot collect debt in this state if you don't have this. So y'all trying to make it seem like I'm wrong for saying this statute is crazy. Like, oh, well, why you want to know that? Because I can. You're not supposed to try to come after me for nothing if you ain't got this surety bond. Let's be real. Did I feel defeated? Yes. Yes, I did. But I had to get myself together. I had to read and come back together and realize, what's my next step? What is my other step? Do I have more options? Now, appeal process is expensive, but I'm doing it pro se, and I already was approved for a fee waiver, so I'm approved for a fee waiver when it comes to the appeal process. And once they go back, they're going to find that he misapplied that, because you are saying it in a sense of because they attain a lawyer, the lawyers, whatever protection the lawyers have is extended to this company, and that's not what that law says. That is not what that statute say. Therefore, you should have never exempted them, because I never said I was talking about the attorneys. No. So you tried to be funny, but that's fine. And another thing is, too, even if that didn't work, y'all, I have a whole nother way, too. I have a whole nother way. They just don't expect people to fight, and that's the problem. That's the problem, because they think, oh, they're going to do... No. I don't settle. I don't settle, and I don't give up. Not with debt collectors, because it's different. It's different, right? So boom. But the attorney office is shady, y'all. If y'all see, I looked them up, yo. They have cases against them already, and I'm just like, why are y'all still in the business of practicing if y'all already been? That's my thing. If somebody is found guilty of something, because as soon as it's an individual and they're found guilty, y'all gonna put them under the jail. But as soon as a company or something is found guilty, y'all find them and then let them continue to practice. If you already been found guilty of deceptive practices, why are you still able to continue? But there's also a list of collectors that cannot that have been banned from collecting, and that tells me that sometimes justice it is served. It just might take a while. It might take a lot of people, unfortunately. But trust me when I tell y'all, they finna know me. Them courts is finna know me. Sue me if you want to. If I have an arbitration clause, we're going to arbitration because I feel more comfortable. If I gotta go in there, I probably try different strategies in a courthouse, and if not, I'll appeal it at the end of the day. But yeah, it's just it's frustrating. It's a process, and I know how some with people who are not willing to keep going forward and push forward with this type of stuff, it's something that it's hard to kind of continue with, because it's like it's a lot, and I get it. But y'all cannot give up, y'all. Y'all cannot give up. Listen, I told y'all in my last video, when the one that's against LV Envy that I actually filed with in arbitration with, right? When I tell y'all the strategy that I'm using, the strategy I'm using with LV Envy is different because I never got to litigate that case. So I'm using all my counterclaims and I'm putting them into arbitration. Not all of them. Well, yeah, all my counterclaims, because they are still even though they got the default judgment against me, it still applies. They're standalone is basically what I'm saying. So if you are somehow violating, the law, then those claims can still be heard, even though it is connected to the default judgment they already have. I'm not trying to get the arbitrator to overrule that. I'm just trying to get them to show, hey, they have been violating it. They violate, and this under these claims, this is why, and this is all that needs to be addressed. This judgment can stay there now. If they want to settle and say, well, I don't know if you can even retract the judgment, but if they want to say we'll retract this or whatever the case may be, fine. But if not, y'all are going to be found liable for it, especially y'all. LV Envy, I know I got it in the bag, and this is not even on no cocky stuff, but y'all, the actual bond that they were supposed to obtain prior to the date of suing me was 7 days after I was able to validate that with my state. So because of that, they should have never been able to practice debt collection practices, which includes filing a lawsuit, because you are not a owner of it if you can't even practice in the state. You get what I'm saying? So therefore, I know that's a no-brainer win. That's a no-brainer win. I already have the proof from that. So it's a no-brainer win. Like, I'm really not even about to do no hard work with it. It's already there. So if they are found for that, they already get a fine of $500. On top of that, I don't know what an arbitrator would, I don't know the dollar amount that would be, you know what I'm saying, that would be found, because I just don't, I've never had this happen before. So I already know it's a no-brainer, right? So that is just a matter of getting in front of the judge or getting in front of the arbitrator. I'm not letting this up. But yeah, y'all can't, man, don't let these debt collectors sue y'all. Even if y'all feel like you lost, there's always a way out. There's always a way out. It's just a matter of calming your nerves and then literally finding that strategy. Literally finding that strategy. I am in court with LVMV, or I'm about to do arbitration with LVMV. I am in arbitration with a whole nother company that was reporting inaccurate information on my credit report. I'm in an appeal with Resurgent. I'm about to start another case in the federal. Like, I'm not playing. When I tell y'all these people finna know me by first and last name, cause stop everybody, every single debt collector better take their stuff off of my report, because there's consumer laws here, y'all. Y'all just have to be willing to play the long game, have strategy, and that's exactly what I'm here on this channel to show y'all. How I'm doing it, what I'm doing, my mistakes, how I'm gonna get out of that. I promise you, I just told y'all in my last video how a whole company lied. They lied, y'all. Bold-faced lied in an affidavit, and I knew they was lying because I had the document to prove it, but the affidavit holds more weight than the actual document because the arbitrator asked for that. Y'all, from them lying, I felt like I was done. I felt like we weren't going to continue. From them lying, y'all, guess what? I'm about to start a whole nother case on y'all. Because now I could use y'all lie against y'all, like y'all word, that lie against y'all word with whatever explanation y'all use now. And it's a different angle. Like, I mean, this is nothing but God. I have to get a props to God because when I tell y'all, I ain't nobody. I promise you I ain't nobody. I just don't like injustice. Like, when I wanted to be a lawyer, I promise you I wanted to be a lawyer because I felt like lawyers was actually helping people. I just feel like nowadays, I don't know, from stuff that I see and come across, it's either a money grab or it's the fact that it's either a money grab or it's just another case number. Like, y'all not giving people the actual like, some, not all, but some are not giving the actual people, chances, and it's already hard out here. So I'll be the one to take all the hits to myself before, to show y'all that it's possible. Show y'all my mistakes so y'all don't make the mistakes. Perfect it for you so that you can use this information to move forward. But there's consumer laws for a reason. There's FDCPA laws for a reason. Take them to federal court and don't let up. Period. Because Resurgent thought I was done. We're in the appeal stage now. And I already have another strategy if they try to get out of that. Because my thing is, whatever I'm found for, because most of the debts that they came after, it's like $600. Like, the most was $2,500. The other one was $600. I think I had another one that was like $400 or something like that. That was a whole utility account, but whatever. But Resurgent thought that I was gonna lay down and shut up. And then they tried to put the pressure on me because you tried to do a bank levy. And then I'll do the same thing for that company. Find all of the ones that they had sued people for in the county that I was in. Find all of them and then report them. And then give it to a lawyer and let's see if we can get a class action. Y'all finna know my name. Y'all get these lawyers, y'all get these attorneys, y'all send these letters, y'all send this, y'all send that, just to get people, just because y'all know people operate out of fear. Baby, I am a child of God. I am a child of God. I don't operate out of fear. That is not how we do stuff around here. I don't mind losing a little 1-2, but it's always a way out. God is always gonna see me through. So that's my case with Resurgent, y'all. They think that it was over. It's not. It's not over to the fact that it seems we are in appeal process. I will let y'all know as I go how things go turn out. I do real live updates on through the YouTube Reels. So if y'all want to subscribe to see those as they come along. But y'all, if y'all are like me and y'all pro se and y'all want to fight these debt collectors, please don't give up. Even if you lose, it's always a way out. Even if you don't go to appeal process, it's always a way out. It's always a way out. Because what one of the strategies that you can use, even if you lost and you took them to arbitration for claims that connect to the dollar amount, but not exactly about, like, you're not trying to challenge the dollar amount or nothing like that. You could still, you would just get them, you find them liable and get them to pay for the debt, for the judgment that they got on you. It's always a way out. If y'all like this video, don't forget to like, comment, and subscribe, and I will see y'all in my next video. Thank you for watching.